Good morning, everyone. Thank you for joining. I'm going to wait a few minutes before I start so that people can hear the whole thing. Good morning if you have just joined. Welcome to this second webinar. It should be suitable for those who attended the first and also for those who didn't attend the first one. We'll just wait a few minutes for people to join. Again, good morning if you've just joined. We'll start in a couple of minutes once a reasonable number of the accepted people have joined. It's only just 10:30 so far. Good morning and welcome to this second seminar. We will start in a couple of minutes once a few more people have joined. This should be suitable for anyone who listened to the first one because there are quite a few updates, and for people who didn't listen to the first one because I will also cover briefly all the ground. Okay, one last welcome before the real one. Welcome to this second seminar on how NSIPs are working during the pandemic. Let's wait one more minute for people to join and then make a start. Okay, I think I'll make a start now. Other people can join and they won't miss much at the beginning. So here we are. Welcome, one and all. This is my second ever Zoom seminar. So things may go wrong. I hope they don't. Please be forgiving. My name is Angus Walker. I'm a partner at BDB Pitmans, and I specialise in infrastructure planning, in particular DCOs, NSIPs, whatever you like to call them, working on a number of such projects, both for promoters and sometimes third parties. So I'm going to take you through how this regime is working during the pandemic. I did do a seminar 3 weeks ago. It seems a lot longer than that. Time is moving very slowly at the moment. But in fact, quite a few things have happened since then, so do stay tuned even if you heard the first one. I do encourage you to ask questions, and you can do that by clicking the Q&A button that should be on your screen and typing them in. I've learned from the first seminar that your questions don't appear for everyone to see unless I click them, so I will do that before I answer them this time. If you have any technical issues, could you use the chat function separately? You should have a chat button. My colleague Melissa is monitoring the webinar, and will try and solve your problems, but obviously if there's something happening at your end, she can't go around to your house. So we will try our best. I think there are sometimes sound problems, but I hope they are temporary. So this talk is based on a paper I produced about a month ago that when you get the slides, you can click on the blue link there on this page. And that in turn is based on a much longer paper produced by the National Infrastructure Planning Association, of which I am the chair of the board, which was sent to the government and the Planning Inspectorate and has been responded to. Finally, by way of introduction, you will get a note of any questions people asked and answers I've given, or perhaps only the ones I have answered. Copies of these slides, and indeed this time there will be a link to the recording. I think this is going to go on YouTube in due course, so there's no need to take notes if you don't want to. Right, let's move on. So here are the topics I'm going to cover. These are all the things that have been held up in some way or are more difficult because of this pandemic and restrictions on movement, gatherings, etc. So the most obvious one is that there are a lot of requirements for documentation to be deposited impliedly in physical locations for people to inspect. Similarly, site notices are supposed to be erected for various reasons, and that may be difficult. And in any case, if either of these things could happen, would anyone even go and see them, these documents, or look at the site notices? Land referencing is an activity before statutory consultation that may not be able to be carried out in the same way because visiting people may be more difficult. There's often a stage of door knocking. Site surveys in preparing environmental statements and so on either can't be carried out because people can't travel, or even if you could carry out things like traffic counts or air quality measuring, they wouldn't be representative because there's much less activity at the moment. Then there are consultation events, which can't be held in person. Hearings, again, and preliminary meetings that can't be held in person. And finally, DCOs that have been granted some time ago and may be reaching the limit of their deadlines for implementation. They may be expiring. So I will deal with each of these topics. and then I'll have a little moment at the end of each one where you can ask some questions, or ask them at any time, but I will answer them at the end of each section. So the first one is document deposit and site notices. As I say, the law certainly assumes that physical deposit and site notices are required at various points in the process, and I list all the points there. There are 8 there. 6 of them, there's no discretion, although the one site notice that's supposed to be placed near the site of a project to notify about hearings, that is one that can be waived by the examining authority. And I'll come to that in a moment about what's happening in practice. So no need to read those all out, you'll be able to see them when you get the slides. Unfortunately, there has not been any change to legislation yet, but I am assured that MHCLG are thinking about this. So I hope there will be some announcement soon. And indeed, there have been changes in other fields. There's one of the most recent examples, and probably the most wide-reaching because it affects all planning applications. Doesn't require physical deposit of materials relating to planning applications. So let's hope something happens soon in relation to DCOs. There have been some changes in practice, though, to report. Note that I put in green things that have happened since the last webinar, so that if you did attend the first one, you can jump straight to those. There are some consultations that have statutory consultations that started before the lockdown and other restrictions happened, but finished after that. So there are some examples there. There haven't been any that have been entirely during the lockdown yet. So I give an example, section 48 notice. That's the notice where you advertise that your consultation, you publicise that your consultation is taking place. I mentioned about the waiver of the site notice that's possible if the examining authority agrees to it. On a project we're working on, the M25 Junction 10 for Highways England, we indeed asked for that waiver. The examining authority agreed, but they did also require an additional newspaper notice to be published. And that's quite a typical quid pro quo, that things are allowed to continue, but to compensate for things that can't happen, you have to do more of the things that can happen. The South Humber Bank project, which has been accepted for examination, started its representation period last week. And there's a link there to the section 56 notice advertising that. The period is 7 weeks. I don't know whether that's longer than they were planning, but it probably is, because most representation, the minimum is 28 days. Most people have a bit more for any problems that happen at the beginning, and theirs is 7 weeks. They have some innovative ideas in their representation period, which could apply to consultations as well. You can actually borrow hard copies of the examination, so quite trusting of them that they're going to give them back, or borrow e-readers that have the application on them. And although the traditional deposit of deposit of application documents at libraries and so on is not happening, there are still 2 physical deposit locations, one at the site office of the project and one at the developer's office. So those are much more in control of the applicant. And even then, they're only by appointment, so you can't just turn up. So there are some examples where compensatory activities have been carried out, which I find quite interesting, and people might wish to adopt in their own consultations or representation periods. So moving on, it would help if there was a change in the law, because even though things are continuing, the applicants, developers are taking a risk in not physically depositing things when the law technically requires them to do so. And indeed, the planning inspectors are taking a risk themselves by allowing people to do this and still accepting applications and allowing representation periods to take place. So I think we're all very grateful that the planning inspectors are doing all these, helping all these steps, but these risks would be avoided if the government got round to allowing or explicitly saying in the law that virtual access to documents would be acceptable, even if it's only during the pandemic, but it could be generally, who knows. There was a government statement on the 13th of May, there was a link to it there, that says in general they want things to continue, so that's helpful, but it is pretty general. It doesn't say you can have virtual deposit of documents. And last week there was another statement which does specifically address that, but it only applies to traditional compulsory purchase orders, not to DCOs. I've reproduced the text of the relevant paragraph there. So it starts, the government considers that publication of the order and map online fulfills the requirements to publish in a place. So if it's good enough for them, it should be good enough for us in the DCO world. However, a change in the law would be the best solution. And even that won't save projects that have already gone through these phases, potentially. And so they should hurry up, please. Moving on, actually, well, since that's the end of that topic, are there any questions and answers? Anyone would like to ask? I'll just pause for a moment. No one's asked any yet. No, okay. So it may be that this seminar takes a bit less time than the previous one. I'll definitely try and end within an hour. It may be less than that. Let us move on then to land referencing. Nothing green on this page, there's nothing really to say. The law requires a standard of diligent inquiry, so there's no, it's not written into the black letter of the law to say you've got to knock on people's doors, but normally if questionnaires sent in the post or delivered by hand aren't answered, then another stage is to knock on people's doors. That may be difficult, but then again, it may still be possible. There's nothing to stop absolutely knocking on doors, so that may be possible, but again, it may take more time to establish land interests. And that's the second theme. The first theme I mentioned earlier is that if you can't do some of these activities, you will have to do more of other activities. The second one is you will generally need to allow more time, unfortunately. I say unfortunately because all projects are always in a terrible hurry to get applications made and consented, but this isn't going to be possible as quickly as usual. Allow more time during consultations, for example, because it'll take longer for people to receive and understand the documentation and B, make their responses possibly. So no change in the law is needed, but reassurance about standards of diligent inquiry would be of assistance. So that's a fairly brief topic, but a necessary one. Let me move on to site surveys, which is probably the most challenging topic and interesting one, therefore. As I said earlier, the two issues are, it may be difficult to undertake the surveys, and even if you can undertake them, they may not be representative because there's nobody there. I suppose biodiversity surveys, on the other hand, might actually have larger findings than normal because animals are returning to many sites. But ones like noise, air quality, traffic, so on, are obviously much lower than usual. Of course, this affects environmental impact assessment most prominently. It also affects those categories within assessment, environmental categories that have particularly high thresholds of compliance. So I've given 3 there: habitats, air quality, and water quality, because these are ones that, whereas generally environmental impact is a balancing exercise, and if you have an impact, you're still okay as long as your benefits outweigh that in those impacts, the total of those impacts. These ones have an absolute standard that never mind how beneficial your project is, that will never outweigh certain harms. Those being habitats, Natura 2000 sites, SPAs, SACs, all that lot. Air quality, if you are going to breach the limits with your project, then you can't have it. And there's similar questions about water quality as well. So what to do? In terms of physically carrying out the surveys, that is still okay, apparently. I mentioned this last time. The letter to the CIEEN says that ecologists and environmental professionals should be able to continue with outdoor work, including ecological surveying and supervision. That green text there is not because it's new, it's just that the colour that DEFRA puts its website in is green. It seems that the only bit of creativity a government department is allowed to have in its logo now is the colour of the stripe on the left-hand side. DEFRA has chosen a green one. There we are. So in principle, it is possible to carry out the surveys, although maybe some types of survey you can't because of their nature, and it requires people to gather closely together or whatever, too closely for social distancing. So it still might be possible for some types of survey not to be undertaken, but in general, that should be okay. What about the fact that they are unrepresentative? Well, here is one development since the last webinar. This is one forthcoming DCO project, Oikos. It is an energy project, not a yogurt project, and it has sought and received a scoping opinion. So first of all, it's very good news that the scoping opinion was sought and received during the within the statutory 42-day limit. So PINS must have worked hard to achieve that. And certainly if you are planning on applying for a scoping opinion, the more notice you can give PINS and indeed other parties that you're doing so, the more likely you are to allow them to achieve the 42-day limit. So here is a quote from the scoping opinion where it recognises that the pandemic may have consequences for an applicant's ability to obtain relevant environmental information. So it talks about adopting a flexible approach and asking relevant bodies to also adopt a flexible approach. That there must be suitable rigor and scientific certainty in assessments, but pragmatism as well. So the third paragraph is probably the one to pay attention to. Make every effort, or make effort, not every effort, just effort, to agree your approach to the collection and presentation of information with the relevant consultation bodies. And the inspectorate expects the consultation bodies to work constructively there. So it's not the most concrete advice, but it is very helpful that inspectorate are conscious of the difficulties and recommend collaboration with the bodies that will be opining on the scoping report and the approach of applicants. This is an approach that I did mention at the previous webinar. It is not a new one just because of the pandemic, because it is quite normal for the ability to survey the entirety of the land not to be possible. HS2 being a prime example, a very long linear project. So not only is there a huge amount of land, but obviously there are lots of people who don't want people on their land at all, who don't want the project, so they won't let people on the land to do their surveying. So the approach assumed is at the end of this paragraph there, a reasonable worst case. So where you didn't get onto some land, you assume the worst in terms of impacts of likely species on that land, that there are loads of them. And so you have to design your mitigation, over the top mitigation, in case there are in fact loads of them. This is the reasonable worst case approach. So, although there is no point in changing the law in this case, because surveys can continue and the problem is not their ability to continue, but that they are unrepresentative and no amount of legal change will change that. The possible approach is this reasonable worst case approach. So obviously, if you haven't done any data gathering, this may not be possible. But if your gaps aren't too big, you may be able, and they don't affect those absolute areas like habitats, perhaps, but maybe there's even a way around that. If they aren't too big, use this reasonable worst case approach. So it means you will have to oversupply or over-prepare potential mitigation. So that may need more land. But as long as you only need to implement that mitigation if the worst case is realized, then you probably won't need it in the end. So that's a potential approach for getting around some gaps in your environmental assessment. I do think, so that I haven't actually put it on the slide, that you may need to say what you would do if it was even worse than the reasonable worst case you have assumed, just so that every eventuality is dealt with. So that may be that you have to stop construction or something until there's a reassessment of an additional mitigation proposed or something like that. But I think you do need to cover every base, because otherwise there may be suspicion that what you say is a reasonable worst case is not in fact the worst possible thing that might happen. So those are my suggestions. I'm not an environmental expert, and there are plenty of them who can advise you on this area, but hopefully there are ways around some gaps. So I'll pause again for any questions, but I did have quite a lot this time. I mean, on this issue last time. People aren't so chatty this time, but that's fine. An interesting development, perhaps related or not related, but to do with the mitigation, because I was asked last time, how can you, for example, seek compulsory acquisition powers over land that you would only in extremis ever need for this worst case effects? It's worth reading the Cleve Hill Solar Park decision letter, because although it wasn't for this worst case mitigation, there was land subject to compulsory acquisition for biodiversity net gain. And I have previously been of the opinion that one should be cautious about seeking powers for net gain until that is a legal requirement, because net gain is clearly over and above biodiversity land to offset the effects of your project. It's over and above that by definition. In the Cleve Hill application, they were seeking land for biodiversity net gain. The examining authority didn't think that they should be given powers because it was gain rather than to offset the impacts of the project, and therefore was it arguably associated development, and was there a compelling case for it, etc. However, the Secretary of State did allow this land to be subject to compulsory acquisition. Okay, I've had a comment, so let me let you see that one. Thank you. Not really a question, but survey access is a problem that affects survey data gathering anyway, so it is something EIA teams are already dealing with. Well, yes, good point. As I say, HS2 had problems with survey access, and that wasn't because of the pandemic. The recent Sawkill case is of some relevance there because although it's slightly ambiguous as to whether any potential DCO applicant can use the new power under Section 172 of the Housing and Planning Act to seek compulsory access onto land for surveying, which is a much simpler process. This was challenged in the case of Highways England for the Stonehenge project by a landowner, Mr. Sawkill, and the judge decided that the usual DCO method of Section 53 of the Planning Act and this new Section 172 are overlapping powers, and they are both available to Highways England at least. The ambiguity lies in that the judge seemed to suggest that only parties who already have compulsory acquisition powers other than through the Planning Act 2008 may be the ones that can do either of these methods, and people who don't may not be able to. However, I don't agree with that. Am I allowed to say that? I'm sorry, Mr. Justice Dove, but the having compulsory acquisition powers condition is, of course, in my interpretation, that includes powers under the Planning Act itself. There's nothing in Section 172 that says you're an acquiring authority for some methods of acquisition and not others. It's all types of acquiring authority, and that includes the Planning Act. So I'm not giving you legal advice, but I think anyone can use Section 172 if they're a prospective DCO applicant. Right, I've had another question. Let me let you see it. Regarding baseline monitoring for water and air quality, I understand your comment about breaching limits will not be allowed. However, if the baseline is recorded as unusually low due to the current lack of economic activity, is there a risk that consent will be awarded based on incorrect information? Well, yeah, if you're going to measure air quality and find it's terribly low because there's nobody doing any pollution, no cars going past, for example, and then you add your project on the top and say, look, it's only gone up to 38 micrograms per cubic meter of NO2, for example, and the threshold is 40. Well, I think that would be a bit of a false conclusion, because that's not the what the true baseline is. And so if it was 10 or 20 micrograms and you're adding 38 or 35 or something, then you would exceed the 40. And so your project should probably not be allowed unless you can bring down your air quality impacts. So, well, there is a risk, but obviously examining inspectors and secretaries of state should be aware, should be alive to the fact that the some baseline calculations may be unduly optimistic and check that during examination. Hope that answers that question. Right, let me move on to consultation, I think is the next one. Consultation events. So I've changed I can't remember what the previous word was, but some projects have had partial consultation during lockdown, but there is still not one that has started statutory consultation during lockdown. So I think all the current practice has at least held some physical events, although they couldn't hold all of them and stopped before the end of the ones they were planning. but there is not yet a project to my knowledge that's searching for Section 48 notices in the London Gazette, which is where they must be published, which is a helpful way of finding out whether statutory consultation is being undertaken on projects. I haven't seen any that have started their statutory consultation since lockdown and other restrictions began. On the deposit and access to documentation side, I mentioned earlier the South Humber Bank application, which is doing its representation period fully during the lockdown restrictions. So there are parallels to be drawn there. So the only difference with consultation is the holding of events. So it is possible, of course, to hold webinars like this one and other events where online events where experts can be quizzed by people who wish to join in substitution for physical events. All the main consultation expert companies are developing online consultation event packages, and you can no doubt ask them for their advice. I gave one example of a project that is going to start its consultation, which is the London Resort, the theme park and entertainment resort in North Kent, which is going to, although it has already done one statutory consultation, so at least it's got that in the bag with physical events taking place. It is planning a second one because the project has changed somewhat and time has passed, starting next month. So that will involve online-only consultation events, unless halfway through the lockdown is eased to the extent that physical events can take place, presumably. So watch that space. No doubt other projects are also developing online-only events. But that is definitely not an insurmountable issue. If you have produced a statement of community consultation, i.e. the statement that says how you are going to consult, and it talks about online, talks about physical events, then you will probably need to re-consult on that, because it is clearly a significant change to your consultation not to have physical events, and the adequacy of the compensating online events or online activities will be something that the local authorities will want to comment on. As in other areas, stepping up the non-contact activities to achieve at least the same standard and reach as having physical events. And indeed, it may be possible to extend the reach. This is one area where I think improvements, you can reach more people who can't physically travel to an event because it may be too far away, or they may have access issues or something. And definitely it's recommended to check statutory bodies in advance for how to get in touch with them, because if you just send your statutory consultation information to your usual address or email, it may be sent to an office that is closed, or people are working from home, or people at email addresses may not be checking them because they are furloughed or whatever. So alternatives may be in place. So it's definitely a good idea to find those out before you embark on your statutory consultation. So no change in the law is needed here, because there is nothing that requires physical events to take place, other than the change that applies to other areas about physical documents. That would be a good idea. Again, a statement that consultation can continue if appropriately adjusted would be helpful. So let me see, I think I've got a question. I've got 3 questions indeed. Right. Thank you for your questions. So first one, great seminar, thank you. That's one way to get your question answered. A consultation-specific question. If consultation is held primarily digitally first with online feedback capture, what is the legal view of requiring consultee registration with an email as a requirement before feedback can be left? Would this be viewed as a barrier to a legitimate expectation to leave feedback? Well, I guess this is about consultees not wishing to give personal information about themselves before they give feedback. Well, off the top of my head, it is certainly more helpful to provide information, particularly about where you live, because then the potential applicant can do some sort of heat map of where people are responding and work out the sort of particular issues that someone might have if they live in a particular area that's affected by a project. So that is a matter of course is generally sought by through consultation. I don't think applicants should stop anonymous responses, but it's difficult to see how much weight to attach to them if there's no information about who the consultee is. So they should be, they are still consultation responses, so they must be had regard to in the consultation report and by the applicant, but perhaps less weight needs to be given to ones that are totally anonymous. That's the best I can say on that one. Next, there are some real positives of online consultation as more people can potentially access this info. Sorry, I'm not publishing that one. As more people can potentially access this info who may not have been able to attend in person, including those with disabilities and other responsibilities. Virtual exhibitions are possible. Getting to the harder to reach groups will be the challenge. Well, I totally agree, and I think this is somewhere where we can have a lasting benefit to projects in an area even after the pandemic is finished, if it ever finishes, but even after restrictions are more or less back to normal, that those who were not physically able to attend events can attend online events generally more easily. There are still people who may not be able to attend physical events or online events, and they should still, every effort should be made to allow them to participate in the consultation, of course. I think there is more focus on harder to reach groups. One way is to contact representative bodies of such harder to reach groups, if you can identify them, either local ones or national charities that are responsible for people with particular characteristics or whatever. But that is always a challenge and remains a challenge. But I think this is one area where things can be in a better place afterwards than they were before. Third question, thank you. Do you think that a promoter should hold pre-submission, ES, final environmental statement, finalisation and consultation if the statutory consultation took place more than 2 years ago? Would your view change if the approach to this engagement had to change and so amend the SOC? Well, I can't give a categorical answer. You may have a particular project in mind, and I don't necessarily want to give ammunition to anyone. On either side, it is a matter of professional judgment as to whether a further statutory consultation should take place, given if one took place some time ago. Obviously, the longer ago it took place, the more likely a new one ought to take place, because even though the underlying project may be the same, the baseline is likely to have changed over time. If the project itself has changed, then that is another consideration. The two main considerations are, has the project changed and has the baseline changed? And it's up to the developer to take a view on those as to whether to hold a further statutory consultation. If they don't want to go through the full panoply of a statutory consultation. Of course, there's always the availability of a non-statutory consultation, which runs less risk of making a legal error because there is less legal hurdles to overcome. That's that one, and I've got another one here. I'm blithely publishing them before I even read them. I agree with the comment about positives around virtual consultation, but it is important to remember that some people don't like engaging online or don't have the facilities to do so. A hybrid of consultation methods needs to be used, which must also be COVID-19 safe. Well, good point. Of course, you may be able to access more people that wouldn't have been able to go to a physical consultation, but there are also ones who would have been happy to go to a physical one, but don't want to do it online. So need to be aware of that. And it is not simply sufficient just to have an online only, totally online only approach. So as my paper and the NIPA paper in more detail, they talk about, and indeed looking at that South Humber Bank consultation, you need to have some other ways as well as just online only, such as some ability to receive physical documents, some way of conveying your response either by post or by phone or something. So make sure you are compensating and thinking about all the different types of people who might wish to participate in the consultation and who are affected by the project. Okay, I have about 15 minutes left, so I think it's time to move on. Thank you for your questions, they're very welcome. Hearings. In a way, this isn't particularly an issue for applicants to worry about and developers, because it's the planning inspectorate's problem mainly, but obviously it's of great interest. So the issue for applicants to be aware of is certainly that hearings and eventually preliminary meetings are going to take place online, but they are probably, to compensate, going to be spread over a longer period. And it may mean that the whole examination gets extended as well, although I'm sure the planning inspectorate's ultimate aim is not to extend examinations. But during this temporary sort of testing of online alternatives, inevitably some examinations have already been extended. So what's happening in practice? There's two projects who are planning online hearings, A38 Derby Junctions and M25 Junction 10. Derby Junctions has the privilege of being the first project to have an online hearing, and it's taking place next week. That's on Tuesday next week. I should say that I don't think the planning inspectorate really want hundreds of people who have nothing to do with this project just to join the hearing because they're nosy about how it's going to work. So, so I'm sure they would welcome me to say, don't all pile in on that project, please. But I'm sure we'll all wish to hear how well these hearings went. I do understand that the planning inspectorate have been testing hearings online and have tried to have examples of people who have connection problems and who are being disruptive and all sorts. So let's hope these hearings go well, because it will be good for everyone. This will allow further hearings to take place. In green, so a new development, another project that actually has had its examination extended as well. Norfolk Boreas Offshore Wind Farm is having some online hearings that have now been timetabled from the end of June to the middle of July. So that's quite a long period. Look, that's it's 3.5 weeks of hearings, not every day, but shows the spread out nature that is going to be the replacement of our physical hearings, which were much more concentrated. That's not to be confused with the Norfolk Vanguard, sister project of that one, which is at the decision stage. The decision was due on Monday, but has been delayed until the 1st of July. So that will happen in the middle of those hearings. Right, so those 3 examinations have all been extended. However, in line with my earlier comment that hearings are, examinations are, it is hoped will not need to be always be extended even during online hearings. The A1 Berkeley project is planning some online hearings in June, but so far has not planned an extension to the examination. That's because it was a lot earlier in its examination than those other projects. The Kemsley, interestingly, I think this is an Energy from Waste project, has issued, the examining authority has issued a revised examination timetable with no hearings in it. So it's all being done in writing. So that may need to be revised further, but at the moment that's the approach on that one. Finally, some news on preliminary meetings. In a way, this is the final piece of the jigsaw, because once it's been possible to hold a preliminary meeting online, every aspect of the DCO process will have been converted to an online equivalent. And this is being explored with the Aquind Interconnector project. It originally had a date for a preliminary meeting that was cancelled because it was after the start of lockdown. And the Planning Inspectorate have now issued a questionnaire for those parties affected to say whether they can cope with an online preliminary meeting. And that the deadline for that questionnaire has now passed. It was on Monday. So we'll see how that progresses. Okay, I've got a question, I think, a couple of questions. Presumably you would have had to register as an interested party to get access to online hearings. I'm not quite sure the answer to that. Of course, physical hearings, because they are published, people can turn up even though they weren't registered as an interested party. So that may be a bit different for online hearings. I'll have to look into that. I don't know the answer to that one, but it would certainly, going forward, be better if you did register as an interested party to ensure you heard about online hearings. Otherwise, you'll just have to keep looking at the website of the project concerned on the Planning Inspectorate website, the web page, to see what is planned for hearings and see if you can participate. Query over ability to undertake site visits and reliance instead upon photographs, aerial imagery and use of Google Earth. Is a physical site visit a statutory requirement? Well, no, it isn't a statutory requirement, but environmental impact assessment is a statutory requirement. It may be possible to undertake some site visits by aerial photographs, drones, something like that. I don't think Google Earth is necessarily that up to date. It can be up off the top of my head, but certainly Google Street View can be a couple of years out of date. And I read about actually recently on Twitter somebody doing a virtual site visit, not for a DCO, for a planning application, and or for something equivalent to that, and they used Google Street View. Somebody was physically on the site, and others were using Google Street View, and then you get to some crucial view and there'd be a van in the way and you wouldn't be able to see it. So that does have its limitations. So it may be possible to do some measurements by drones or aerial imagery, or just viewpoints, Google Earth, something like that. And there are some things that need like air quality monitoring or noise or something that will need, or maybe you can do noise measurement on a drone. Perhaps the noise of the drone would drown out your measurement. I don't know. So, well, physical site visit is not a statutory requirement, but your environmental assessment does need to be adequate. Sorry, I forgot to publish that question before I answered it, but there you can see it. Okay, thank you for your questions on hearings and other topics. I have 8 minutes to go. So let us move on to the final topic, which is implementation. So generally it requires in a DCO that development must be commenced within 5 years. And although the threshold for commencing development is not great, and once you have commenced it, that you're good to go after that, there's no further, well, there sometimes is, but there's no further general time limit. And there are also time limits for compulsory acquisition powers to be exercised. You must issue your notices within a certain number of years, often again 5 years. And some projects that were consented around 5 years ago, or nearly 4 years ago, are nearing that deadline. So although they were all perfectly fine, pandemic-free at the time, they are now affected by it. And while compulsory acquisition, the steps required are not physical ones, they are simply the issuing of notices generally. The embarking on compulsory acquisition is often tied to availability of funding, which itself is tied to starting the development. So that is often a consideration as well. So as I said last time, there are parallels in other fields that have been implemented. For example, the Coronavirus Scotland Act has wholesale extended planning permissions that would have lapsed during the emergency period, or the extended period as they call it. So at the moment we haven't had anything in the DCO world, or indeed, as far as I'm aware, in town and country planning in England. But that is something that perhaps ought to be given attention. So there is a legal change that I and NIPA would really like to see. There are rumours we have heard via the British Property Federation that a bill might be introduced to do this, but I have seen no concrete evidence of this so far, or physical confirmation that it'll happen. So watch this space, I'm afraid, is all I can say on this one. So last chance for any questions or comments on anything I have said. Got 5 more minutes. So I've had some. Here's one. More of a general point query. From what has been discussed so far, the main points I've distilled is that it will take projects far longer and they will have to do more in terms of making provisions for enhanced online consultations, assumptions, enhanced mitigation packages. But nothing has been said about the financial impact and thus future viability of upcoming projects. Has there been discussion on this? I'm not sure I agree with the word far in far longer, but probably longer, yes. And maybe cumulatively, when you add all the little bits that are taking longer individually, that does result in a significant significant delay overall. Well, I haven't discussed the financial impact, but obviously there is one, and it is inevitable that this pandemic is going to have financial impact on projects. Not just because of the delays in each stage of getting consent, but generally because of the economic downturn that the pandemic is causing. And I'm sure the government, I know the government are very keen to limit the downturn and to, in terms of depth and speed in terms of which we recover. So I'm sure they are very, very open to suggestions on how to limit financial impact, not just in this limited DCO world, but generally, so that projects, infrastructure projects in particular, which are often the key to unlocking and restoring the economy after recession, can recover as quickly as possible. Would a 5-year delay require the developer to consider if the policy or baseline position has changed? Okay. So that was further to my remark earlier about how long a delay do you need to reconsult. Well, it is a question of judgment, I'm afraid. It's possible that even a 5-year delay, if the project hasn't changed and the baseline hasn't changed sufficiently to merit a further consultation, that you don't need to do one. But every project is different and I can't really give a general answer. In your blog in 2018, blimey, you mentioned 60% of projects consented had not been commenced. Is this still the case, or has it reduced? Thank you for an excellent seminar. You're welcome. I haven't done any more recent investigation into that. In fact, I think my comment was based on NIPA research in their first Insights paper, where the University of London looked into whether projects had commenced, and that was where that figure came from. We haven't carried out any research with my NIPA hat on the current state of implementation, but that would certainly be interesting for someone else to investigate. Great session, and the first tie I've seen in lockdown. Well, I think I wore a tie at the previous seminar. Maybe you weren't at that one, or maybe it was below the level of the screen. But look, yes, this is only the second time I've worn a tie. During lockdown, I think the first time was the other seminar. What about, final question, what about the inspectors' accompanied and unaccompanied site visits? Ah, yes, I haven't mentioned that, good point. Unaccompanied site visits, I believe, are continuing to take place. Accompanied ones are a bit more difficult because of the social distancing and restrictions on gatherings, so I think they are still pretty much not taking place. But perhaps the compensation is for more unaccompanied ones, with information from parties as to what to visit. With more of that going on, that could compensate, but it may be possible to have limited accompanied ones, but as far as I know, they haven't generally taken place so far. Okay, I think I have finally got to the end of the list of questions, and I've also got to my last slide, and it's 11:29. How about that? Well, thank you. 11:30. Thank you very much for attending. I hope you found it interesting. Because there are plenty of developments in this area, I will have another update one in 3 or 4 weeks' time, probably. So stay tuned and keep safe and well, both physically and mentally. And I hope the projects you're working on can continue. So thank you very much. And I will bid you farewell.